and thank you for joining Thompson Coburn's webinar featuring DEI and anti-discrimination compliance in higher education. Perhaps no issue more clearly underscores the differences between the current and former administrations than the approach and regulation of DEI policies. And above all sectors, higher education stands at a perilous crossroads of competing perspectives. So the question, what are institutions to do? Well, today, we will provide guidance to help institutions navigate these challenges. Thank you for joining us, and my name is Trey Cleveland, and I will be your moderator. I'm also the co-chair of Thompson Coburn's Higher Education Practice Group. I'm based in both of our Birmingham and Washington, D.C. offices, and I represent schools in litigation in all courts across the country. And I am delighted to introduce our standing panel, all of whom are my colleagues at Thompson Coburn. The panel includes a variety of disciplines, including litigation, labor and employment, student accommodations, and regulatory compliance. First, Stephanie Fredman is an associate and trial attorney in St. Louis who advises institutions of higher education on employment matters, specifically focusing on discrimination laws. Scott Goldschmidt is a partner in Washington, D.C. and a former deputy general counsel for a nonprofit institution of higher education and focuses his practice on student and regulatory matters. Brant Hill is a partner and litigator in Birmingham who represents institutions in complex federal cases and focuses on grant funding litigation, accreditation matters, and TCPA compliance. Brant is actually currently litigating a case with the Department of Education that will be discussed in many of the topics today. Laurie is a partner in Birmingham with over 30 years of litigation experience, with particular expertise in mass and class action litigation. Christina Cole is an associate licensed in California and Texas and counsels employers on all aspects of labor and employment as well as Title IX matters. And last but certainly not least, Leah Northerner in our Dallas office focuses on student affairs and policy development. And we have a great, diverse set of experts for you today. A little bit about our firm, Thompson Coburn. It's a full-service law firm with approximately 475 attorneys. We have offices in Los Angeles, Chicago, St. Louis, Dallas, New York, Birmingham, and Washington, D.C. And our higher education practice advises colleges and universities on regulatory compliance, mergers and acquisitions, corporate governance, operational matters, and litigation. We also provide tailored training to support their evolving needs. Before we begin, I want to cover just a few housekeeping items. If you have any questions during the webinar, you can submit those through the question and answer widget. We will try to answer the questions during the webinar, but if we run out of time, it'll be answered later in an email. If you experience any technical problems, those can be reported through the question and answer widget. A copy of today's slide deck will be available in the resource widget. All of our materials, all the links in our materials are live links, and they will take you directly to our source materials. We encourage you to download any resources that you may find useful. You may also scan the magical QR code that's currently on your screen. And if you need to find some answers to common technical issues, you can find those in the help widget. Today, we will be providing CLE credit in an hour in California, Texas, and Illinois, 1.2 hours in Missouri, and 1 hour professional practice credit in New York. You have to verify your engagement to receive the CLE credit through 2 secret words in a multiple choice poll. This is the first, and the answer to this is A, chocolate. So we'll give you just a minute to log your answer, and we will move on. Again, it's A, chocolate.
Trey, are these Valentine's Day themed secret words?
Yeah, that's it. That's it.
I hope so.
Happy Valentine's Day to all.
Yes. All right. I got a joke for you in the next one.
Yes. Well, I can't wait for your humor there, Scott. But speaking of resources, our higher education litigators publish a monthly email newsletter highlighting some of the most significant cases impacting the sector. And our February edition will actually be published tomorrow. And each summary not only provides a clear legal analysis, but also offers practical and actionable takeaways for institutions. So please look for that tomorrow in your inbox and let us know if you have any questions. I would not be much of an attorney if I didn't provide some use and disclaimers. So I'll read through these quickly. Laws and policies are updated regularly. If you're reviewing these slides after February of 2026, please keep in mind that many changes may have occurred. Please note that the purpose of this presentation is to provide news and informational issues on legal issues, and not all content is provided for, and all content is provided for informational purposes only and should not be considered legal advice. The transmission of information from this presentation does not establish an attorney-client relationship with the participant. The participant should not act on the information contained in this presentation or any accompanying materials without first consulting retained legal counsel, which we would love to be, by the way. If you need legal counsel, Thompson Coburn would love to help you out. Just let us know. And finally, if you desire legal advice for a particular situation, you should consult an attorney. And as we start today, Brant, will you provide an overview of the federal law surrounding the DEI policies that we'll be discussing today?
Yeah, thank you, Trey. I certainly will. And good afternoon, folks. Thank you for tuning in. I'm just going to jump right into it and briefly outline the federal laws surrounding DEI that we're going to be talking about here today. And the starting point really is the Equal Protection Clause and Title VI of the Civil Rights Act of 1964. The Equal Protection Clause is in the 14th Amendment to the Constitution, and it applies to states, including state public institutions. Title VI, meanwhile, applies to any recipient of federal funding, and that includes not only public institutions, but the overwhelming majority of private institutions. And the important point for today's purposes is that regardless if you are a public institution governed by the Equal Protection Clause or you are a private institution subject to Title VI, these two laws effectively prohibit the same thing, and that is treating people differently based on race, color, or national origin. And when I say people, I'm referring primarily to students or prospective students. Title VII is the discrimination law that applies in the employment setting, and you're going to hear about that later today from my colleagues. But Title VI is the law that protects students, and together with the Equal Protection Clause, they broadly prohibit institutions from providing or denying benefits to students based on their race, as well as their color in national origin. Now, if a particular practice at your institution distinguishes between students based on race or color or national origin, you may ask, is it automatically unlawful? The answer is no, but it very likely is. And that's because there's a very demanding standard that has to be met by an institution in order to justify racial preferences. And generally, the rule is that in order to legally defend a racial preference, an institution has to demonstrate two things. First, you have to show that you have compelling interest in achieving a particular goal. And second, that your racial preference is narrowly tailored, meaning that it does not burden non-preferred races any more than is necessary to achieve that goal. This test, this standard is known as strict scrutiny, and it's very difficult to meet. For decades, affirmative action at universities had met that test. The Supreme Court, for a long time, it said schools may have a compelling interest in student body diversity, such that they can be allowed to consider an applicant's race as a plus factor in making admissions decisions. But that is precisely what the Supreme Court struck down in 2023 in its landmark Students for Fair Admissions versus Harvard case. The Supreme Court essentially said that race cannot be used as a plus or a negative factor in admissions. And it was very clear in its opinion that Eliminating racial discrimination means eliminating all of it. So we know race cannot be a determining factor in admissions, but what about the many other aspects of campus life? What about affinity groups? What about private scholarships? What about providing academic support programs to minority students? Well, that's exactly what we're going to talk about today. There are a lot of open questions as to the scope of the Supreme Court's decision. Immediately after it, the Biden administration took the position that this decision only prohibited affirmative action in admissions, but it didn't extend to other areas of campus life. But as you're about to hear from my colleague Lori, the Trump administration, of course, through executive orders, dear colleague letters, OCR investigations, grant terminations, and so forth, has interpreted that Supreme Court decision very broadly, such that this administration contends that it means that racial preferences, DEI practices, and racial proxies are all unlawful. And regardless of how you view the Supreme Court's decision, there is some support for the Trump administration's broad interpretation of that ruling. As you'll see on your screen, there was a court that after that decision came out and said, students for fair admissions concerned college admissions programs, but its reasoning is not limited to just those programs. And there's a kernel of truth to that. The Supreme Court cannot address every actual situation. It takes a limited number of cases per year, but when it issues opinions in those cases, it gives guidance to lower courts and regulated parties about related issues. And that is arguably what it did here in the Students for Fair Admissions decision. And so there is a legitimate argument that that ruling, although it's technically about admissions, applies more broadly to other practices at institutions. So with that, I'm going to pass it back to Trey and then Lori, who's going to dive into exactly what the department has done over the past year or so.
Brent, thank you so much. And that's such a great point. If you're looking for a roadmap of what the current administration would like to see, the Students for Fair Admission, that opinion will provide what this administration is trying to expand as far as that opinion to all aspects of higher education. So, Brant, great insight. And Lori, can you give us an update on where things stand with the DEI executive orders and the Dear Colleague letter?
Yes, thank you so much, Trey. Thank you, Brant. So the DEI executive orders, immediately after President Trump was inaugurated, he issued 2 executive orders targeting illegal diversity, equity, and inclusion initiatives in connection with federal grants and contracts. And those DEI executive orders were immediately challenged in court. 3 main provisions that were challenged. So there's the termination provision, which orders agencies to terminate all equity-related grants or contracts, and we've seen a lot of that this year. The certification provision, which instructs the head of each agency to include in every grant or contract a term requiring the recipient to certify that it does not operate any programs promoting illegal DEI. And the enforcement threat provision, which basically called for a plan to address all of this. As I mentioned, they were immediately challenged in several cases. One case got ahead of the others. It was filed in the District Court of Maryland. That judge enjoined the executive orders. The government appealed. The government sought a stay, which was granted by the Fourth Circuit. So the DEI executive orders remained in force. And then just 11 days ago, on February 6th, the Fourth Circuit vacated the injunction, holding that the plaintiffs did not meet the high bar for a facial challenge. The plaintiffs were challenging the DEI executive orders as a whole across the board, as opposed to challenging them specifically as they were applied to the plaintiffs in the case. And that there's just a much higher bar when you're challenging in a facial challenge. So what this means is that the DEI executive orders are fully in effect, but they are possibly immune in the future to challenges based on specific examples of unlawful implementation as to a particular plaintiff.
Well,
Moving on to the Dear Colleague letter, following the DEI executive orders, the Department of Education released a Valentine's Day Dear Colleague letter last year, broadly interpreting what I call the Harvard decision, the Students for Fair Admission versus Harvard that Brant discussed, to apply not just to admissions, but to all aspects of campus life. Several lawsuits immediately challenged the Dear Colleague letter, and once again, one got ahead of the others in a Maryland federal district court, which vacated the Dear Colleague letter. The government appealed, but just recently the government withdrew that appeal. Thus, the Dear Colleague letter is vacated and no longer enforced.
Well, thank you, Lori. Interesting. So, you know, you've got the DEI executive order still fully in force, and then the Dear Colleague letter, which attempted to do many of the same things, has been vacated. So, good information there. Stephanie, can you tell everyone how the employment laws are affected by recent changes in the DEI framework?
Yeah, absolutely, Trey. Thank you. Just very briefly, I want to go over just a bit of what we're looking at in terms of how some of these changes have affected employment laws, just to give you a little context going into the questions that we're going to address throughout the rest of the day. So as Brant mentioned, Title VII really is the main federal law here that is what is prohibiting discrimination in the employment context, although you need to also be aware of state laws and other federal laws like Title IX and others that do have an impact on employment and employment discrimination claims. Looking at a motivating factor standard, so was an employment decision motivated by a protected class? That leads me into talking about a recent decision that came out of the Supreme Court, the Ames versus Ohio Department of Youth Services case. This case talked about what has been known as reverse discrimination, where the majority group is alleging discrimination in a claim. And this case specifically addressed a circuit split that was looking at whether or not there is a heightened standard for those types of claims. So should a majority group be held to a higher standard when bringing a claim of discrimination? And ultimately, the Supreme Court held that no higher standard should be applied here. This is interesting going into a kind of series of cases that we've been looking at and tracking that address hostile work environment claims. Where hostile work environment claims are being brought on grounds such as training programs or other DEI initiative programs could create a hostile work environment, really against any protected class, but we've been seeing it really often being, these issues are being raised by majority groups. And it's been very interesting to track because a lot of the lower courts have held that these types of programs don't create a hostile work environment. And while many of them are still working their way through different stages of appeals, we are just seeing that this is a question that I think is, the trend is going to be potentially that the Court of Appeals are looking to juries to make the determination of what is objectively reasonable for a hostile work environment claim in today's climate, looking at today's DEI framework. Just remember that the EEOC and the DOJ have put out guidance that have addressed all of these topics, all of these issues. They provide specific examples and kind of no matter what your motive is behind making a decision that might exclude another protected class, that is not going to be something that's considered lawful here, and we're going to address that as we go throughout too. And it's this technical guidance goes deep into really what the administration is thinking and the EEOC and DOJ is thinking in terms of the types of claims and how they arise, and even, for instance, not including issues of disparate impact and only focusing really on disparate treatment, and the fact that moving forward, we may see more on the Title VII context related to these disparate treatment claims and the removal of the disparate impact language.
Well, thank you, Stephanie. I appreciate that. I mean, obviously, institutions not only educate students, but they employ lots of faculty and staff. So the employment issues are very helpful. And also, I think more than any other area of law, employment cases are going to provide some insight as it relates to DEI policies. So with that, we're going to move into what we call the fireside chat portion of this webinar, where we received many questions prior to today, and the vast majority of the questions that we're going to answer and have a discussion on came from the registrants. So with that, let's kick off the fireside chat. And Lori, I believe this question is for you. The Dear Colleague letter has been enjoined, but the injunction as to the DEI executive orders has been vacated by the Fourth Circuit. Those decisions seem to be opposites. So what framework can campuses use to reassess those, to assess those decisions and determine whether reinstating certain language or initiatives is appropriate?
Thanks, Trey. There's been such a brouhaha about these court decisions, but the reality is, with the Harvard decision out there, the outcome of the legal challenges to the DEI executive orders and the Dear Colleague letter may not really matter. After the executive orders were released, the department quickly pivoted to its expansive interpretation of the Harvard decision and really has been relying on that in a major way since. So simply because the Dear Colleague letter was vacated does not mean that the department will no longer view that the examples given in it or in the frequently asked questions that went with it are no longer considered discriminatory. For example, the department in the Dear Colleague letter stated that the use of race in granting a scholarship violates the law. That position is not going to simply disappear because the Dear Colleague letter has been vacated. The department will continue to rely on its expansive interpretation of the Harvard decision. And if an institution is worried about federal funding for the next 3 years, it should evaluate the program or preference by balancing its interests and retaining that funding against the possible risk that the department views an action as discriminatory in light of the examples provided by the Department of Justice July 29th guidance. That is not binding, but it does provide a roadmap for what the administration is thinking as far as what is considered discriminatory. I think there's one question with just about every decision that an institution should ask itself: is this preference or benefit given only to one protected group to the exclusion of another group? And if so, then this administration is likely to view that as discriminatory.
Great. Thank you so much, Lori. Brant, with the Dear Colleague letter gone, do I have arguments to demand a return of diversity programs?
Thanks, Trey. I don't think so, or at least if you're going to proceed cautiously. My answer is going to sound repetitive of what Lori just said, but I think it's sufficiently important to repeat. Whether or not that Dear Colleague letter is in effect is really not all that important. The same could be said of the executive orders, had those been enjoined. This administration clearly views the Students for Fair Admissions decision as supplying it with all the authority under the law that it needs to carry out its goal of eliminating racial classifications and preferences in all industries, not just higher education. And its efforts are really not going to stop just because it has chosen to forego an appeal of the injunction block in the Dear Colleague letter, or because lower courts disagree with its position. There have been a lot of opinions over the past year against the administration, and that has not stopped the administration from continuing to take action. And in fact, just last week, Department of Education representative was quoted as stating that Title VI has always prohibited schools from racial preferencing and stereotyping, and it continues to do so with or without the February 14th Dear Colleague letter. OCR will continue to vigorously enforce Title VI to protect all students and hold violators accountable. And so whether your institution provides a particular benefit should not depend on the legal binding effect of the DCL in the executive orders. And more broadly, it really shouldn't depend on whether someone might label your program or activity as DEI or not. DEI is a very vague term. DEI stands for diversity, equity, and inclusion. And what exactly does that mean? I don't really know, and I don't think anyone else really knows either. To say that DEI programs are categorically unlawful does not answer the hard questions. There are activities that could be considered to fall under the umbrella term DEI that are perfectly lawful, even under the Trump administration's perspective. Conversely, there are DEI activities that are undoubtedly unlawful and have always been unlawful, even under the Biden administration's perspective. And so it's critically important that when you are trying to determine whether a particular practice is lawful, you be more precise about what exactly the practice is and what exactly the goal is. So yes, today's webinar is about DEI, but federal law does not outright prohibit DEI. It prohibits illegal DEI. And illegal DEI is discriminating based on race and other protected characteristics. So Trey, I hope that answers your question, but we can get into it further if you'd like.
Yeah, no, thank you, Brad. Those are some very astute observations, and I couldn't agree more with actually trying to get into the details and the effects of a policy instead of just sort of reading it in a more broad focus could be very helpful to institutions. Moving along here, and this question, again, these are from many of the registrants that provided these before our webinar. We're going to answer it from a campus perspective first, and then from an employment perspective second. The question is, many are reevaluating longstanding identity-focused events and partnerships, considering shifting federal guidance. How should campuses navigate these activities while staying aligned with current non-discrimination expectations? Scott and Leah, can you give us your thoughts from the campus perspective?
Thanks, Trey. I'll start here. And first point, right, is institutions across the country are going to approach this question differently for a lot of reasons. Its mission, political environment, expectations of the campus, and overall risk tolerance. They all vary widely. So regardless of your posture, right, in terms of the things that Brant and Lori explained, the starting point's the same. Conduct a broad inventory of activities that involve identity-based criteria, use DEI-related terminology. And after that inventory, right, so you kind of understand what the scope is, have your campus leadership assess your institutional risk tolerance in light of those factors, right? Its mission, governance, and expectations, and come to a decision. Institutions can then make informed decisions about these pieces on a continuum, all the way from removing or revising certain activities to making modest adjustments to continuing current practices where the institution's comfortable with the risk. And important to note, not all items in the inventory carry the same weight or risk. So important that these decisions are tailored rather than categorical. Leah, what else should institutions be considering?
Yeah, one thing your institution really wants to take into account is what is your campus culture? What do you value? You know, Scott was talking about, your mission, your political environment. You want to consider those, but you also want to consider communication. Because even low risk changes can create communication or can create confusion if not communicated or explained clearly. So be mindful about how these changes may affect recruitment, retention, student support structures, especially in those communities that may have relied on these programs historically. Also, consider your stakeholder expectations and make sure that you're all on the same page. You want to talk, legal, student affairs, HR, advancement, athletics, they all have different assumptions about what's allowed. So you want to make sure that you are all on the same page here. And then, as always, we're lawyers. We say we love the paper. Make sure you're documenting this. Make sure you're showing your insight and your consideration in making these changes, to document it, to show your good faith approach if questions were to arise later, and build in a periodic review of all of these programs so that you are considering, as we have seen, the law changes rapidly. There's different interpretations that come out all the time. We want to make sure that something we put in place last year isn't suddenly out of date this year. So make sure that you're reviewing periodically and regularly.
Well, thank you so much, Scott and Leah. And Scott, your term of institutional risk tolerance, I think that's very important for institutions to determine whether they, there's no secret about what this administration's agenda is as it relates to DEI policies. So understanding that there is a risk in continuing from the administration's perspective to promote those policies. But again, I think that was a great way to put it. And thank you so much, Leah. Christina, can you give us a perspective from the employment side?
Happy to. So let's consider this from a hiring practice, events and programs that are provided to employees. So first, kind of starting out at the base level of state law, I'm going to use Texas as an example. The Texas Education Code itself prohibits institutions of higher education from having a DEI office or giving preference to any applicant or employee based on race, sex, color, ethnicity, or national origin. And that law went into effect in January 2024. So we're talking a couple years ago. And Texas isn't the only state that has this type of law in place. The other states like Utah, Alabama, Florida have passed similar laws regulating DEI-related issues in the employment sphere. And some of them very particularized at higher education, Texas, for example. So when we're talking about this, let's not forget the implications of these state laws. And then moving from there and going higher up into our federal law, of course, there's Title VII and the EEOC and DOJ's guidance limitation on employers, which states that employers are prevented from limiting, segregating, or classifying employees or applicants based on race, sex, or another protected characteristic. Here's the caveat: in a way that affects their status as an employee or deprives them of employment opportunities. So if we're talking about hiring programs or events that would favor a protected class, that would affect their status as an employee, or if it would deprive them of employment opportunities, then we're going to be in that area where it's likely that those programs are going to be unlawful discrimination under these areas of law. Now, of course, we can't ignore that the DOJ just came out a couple months ago in December on the constitutionality of race-based Department of Education programs, right? And the DOJ concluded that most of the discretionary funding programs contain these unconstitutional and inseverable provisions that place the programs in their entirety in violation of the Equal Protection Clause. And consequently, the Department of Education will no longer administer these discretionary funds under many of the grant programs for these minority-serving institutions. For the remaining of the programs, the DOJ determined that the Department of Education could administer the funds only in a race-neutral manner, right? So we've also got this as part of the calculus. So if we're considering the principle, like we've discussed before, of what this administration is getting at, hiring programs that are going to favor a protected class are going to be considered unlawful discrimination, even if we're looking at the DOJ's memo and taking the principles from that and then applying them outward. Now, a note on the DOJ's memo, that there is this kind of separation of powers question. Usually it's not an executive branch agency's job to determine the constitutionality of these statutorily created programs. And eventually we're going to need the courts to weigh in on that issue in particular. So I put a little caveat there for that aspect. Now, there's an interesting interplay between Title VII and Title IX in the employment environment. The Supreme Court has held that cases involving sexual harassment by a student by a school employee or by another student that Title VII liability principles don't apply. But federal courts have often looked to Title VII principles in construing substantive matters under Title IX. So particularly for the sexual harassment standard, the severe and pervasive standard, and the retaliation standard. So there's also this interesting interplay between Title VII and Title IX for employees. With that being said, courts also differ on whether an employee can bring a discrimination claim under both statutes, or if bringing a claim under Title VII therefore prevents the employee from asserting discrimination under Title IX. Now, you should know that a majority of federal courts have held that there's concurrent applicability in the employment discrimination claims. Now getting into a bit more murky area, one area of interest would be if a student or maybe a faculty want to hire an individual due to that individual's particular area of study. And maybe that area of study correlates to a specific race or sex or maybe another protected class. There's a Fifth Circuit case that can kind of inform our opinion on this a bit. Dyke v. Columbia Hospital, which took on the question of whether a hospital can be liable for a hostile work environment created by the discriminatory preferences of its patients. So extrapolating that to the institutional arena, can an institution be held liable for the discriminatory preferences of its clients, the students it serves, right? The hospital serving the patients, the institution serving the students. The short answer for that is possibly. The court clarified in that opinion that even if the employer lacks a formal policy endorsing race-based assignments, informal practices, in this instance, the hospital taking on the patient's preference and changing assignments to employees based on that preference, that informal practices like that may still create liability under Title VII. So all of that to say is that we've got a lot to work with here, and some of it's a bit more clear and some of it's a bit more murky, but we need to take a holistic look at situations.
Well, thank you, Christina. I appreciate that. Yeah, I think the point about informal practices can lead to liabilities is something all institutions could consider. I mean, there's obviously unwritten policies and practices that all institutions subscribe to, and understanding the risks associated there would be very helpful. I also appreciate your comment about this area just doesn't focus on federal law. I mean, obviously, states like Texas and Florida have very different state laws than California and Massachusetts. So very helpful there. I appreciate that. Moving to our lightning round. This is for Scott and Leah. We're going to see how quickly you can answer all of these very good questions from some of our registrants. And we wanted to add that if there is a specific topic that we don't cover today, in case we do run out of time, please let us know in the survey at the end. And we may even consider doing a part 2 of this webinar if there's interest and there's other questions that we didn't get to. But with that, let's start with the first question. What scholarships that highlight students in various categories, women, students of color, et cetera, are permissible?
We'll talk about an area that is a little bit murky. This is one that is very murky depending on the language of your scholarship. So there are scholarships that can be focused on these protected categories in many different ways, right? So we could have ones that explicitly require recipients to meet certain criteria based on those protected categories: race, ethnicity, national origin, sex, etc. And those are going to carry your highest legal risk. But of course, this can be very problematic for institutions because many of these scholarships are actually created through an endowment that establishes that award criteria. So historically, institutions have honored donor intent through things like preferences. So a preference for a woman, a preference for a particular race, etc., rather than those strict eligibility requirements. The idea here was that a preference imposed a lesser burden on applicants outside of that preferred group. But under current enforcement trends, preferences may still be scrutinized the same way as those explicit restrictions if they functionally limit eligibility based on that protected characteristic. So that's something to consider here if you have scholarships that are either explicitly geared towards a particular protected class or are preferred for. And then there's other scholarships that are less explicit about their criteria, simply referencing underrepresented students or minority students or students who do not traditionally pursue a certain field. These are less directly problematic, but they still do raise a concern, especially under this administration that has signaled that it will treat these criteria as proxies for protected class. So if you have a scholarship that's for students traditionally underrepresented in engineering, that may be interpreted as a race-based preference unless you are clear and define your criteria here to not be on those bases. Again, terms like diverse background, marginalized communities, historically excluded groups, not inherently impermissible, but they must be clearly defined. And it kind of brings me to one of the questions that we received in our chat, which is about going through your website to remove DEI terms or those kind of red flag terms. You know, institutions always need to be mindful about what is online. With AI and other tools that are going around, it's really easy for a regulator or just a random third party to scour your website and to find things that they find impermissible, looking for those certain trigger words that might trigger a review. So that is something that you want to look at to see what is on your website. We've done this for institutions before, you know, maybe pull all of those things down while you're reviewing, while you're revising and trying to figure out how to handle some of these scholarships and make sure that they align with your risk tolerance, et cetera, that we talked about earlier.
Well, Leah, that's a great point. And I do want to point out that the administration has put out material soliciting whistleblowers to come forward and to expose DEI policies. So it would be pretty easy for someone inside your institution or even outside the institution to look at some of your publicly available materials and to dig a little bit deeper. And again, no secret that this administration is looking to make examples of schools. So again, I think that's a smart recommendation, is to sort of scour your own information and use Scott's term of your risk assessment to see how risk adverse or risk tolerant your institution is and make a determination if you should change some of your language. But Scott, what else can you add to some of these topics?
Yeah, we'll just go on to the second question. And Leah, thank you for taking the first to talk about a presentation in and of itself. I think that could have been there. So really great with the lightning round. Can we provide information about scholarships available only to students in various protected groups? Here, we probably need more specific details from the questioner, such as the proposed terms of the scholarship and the extent of the institution's involvement, but a few threshold matters or pieces of guidance. Institutions generally shouldn't be barring students of a particular race or gender from applying to the scholarship. We think there's likely some flexibility for institutions in how they notify students about certain opportunities, but the existence of the scholarship right should still be communicated in a way that ensures all students can access the information. And so with this lightning round, we're going to be quick. I'm going to turn the next one to Leah. How can colleges balance benefactor wishes for private scholarships?
I've never been accused of talking too slowly, Scott, so I'll get us through this one as quickly as I can. So this one, like we mentioned earlier, is difficult because many of these scholarships are established by a donor, right? So this is where your communication with your donors is going to be paramount. You need to determine what the underlying goal of the scholarship is and determine if you can revise the criteria to reduce your institutional risk to a level that you're comfortable with. But ultimately, your donor may need to administer the scholarship themselves, maybe make it restricted to benefit the students of your institution, but something that they handle on their side. And depending on your institutional risk tolerance and the goal of the target, the group targeted by the scholarship, you could also consider things like preferences or pool and match for sex-based scholarships, which I think we're going to talk about a little bit later. And Scott, I'll go now to you. Can we still partner with local Native American organizations?
Oh man, and this is another lawyer, it depends answer. I think it depends what partnership means are involved. But for Native American organizations, right, and this was really spelled out in DOJ's recent opinion letter in December, there's distinctions based on political affiliation are generally treated differently from distinctions based on race. So if the partnership provides benefits or preferences explicitly based on race rather than political status, it's likely the administration would view this as discriminatory, but a partnership that relies on tribal citizenship or governance or scholarship, et cetera, may be viewed as political and under a lesser version of scrutiny there. And besides that threshold issue, we probably want to understand the specific terms and activities to really assess risk. All right, Leah, can we still have women, girls in trade events?
Yes. So, this was like a viewer question, and it kind of depends on what your event is. If we're kind of talking about maybe to get, it's like a recruitment event, we're trying to get people to look at these programs. If you can show that the program is open to all sexes, even if it's focused on women, that would be helpful. But do remember that the DOJ memo makes this risky, as it says that programs that are facially restricted to one group do discourage access to others and are thus unlawful. There's also the possibility that you could argue that the historic underrepresentation of women in that particular field has justified the exclusion of men. There is a provision for this under Title IX. It does require the Assistant Secretary to find that the recipient has discriminated against persons in that particular area. So it's not just something that you can outright put into place on your own, but it can be something that's helpful. Again, institutional risk tolerance here of determining what you think is worth it based on your campus culture and etc. Scott, should schools implement a policy where students have to use the restroom of their assigned sex according to their ID?
Oh boy, talk about another webinar in and of itself. So forgive me for this lightning round answer, right? But I like the framework that Christina laid out. Start with state law. Does it address the issue? So for example, Florida law includes requirements that education institutions adopt certain policies. If state law doesn't apply, go to federal law. So federal law is a bit murkier. It doesn't require institutions to adopt sex assigned at birth restroom policies. Some circuits have held differently than other circuits. Ed and DOJ have not issued a nationwide kind of mandate or ruling about sex assigned at birth restroom use. But, right, remember the DOJ guidance we talked about addresses this issue and is more restrictive. This guidance is not authoritative law, but certainly indicative of how DOJ will consider this issue. And this administration has shown a willingness to use civil rights offices to enforce these specific priorities, right, around bathroom issues. So ultimately, a risk analysis for the institution, practical advice, right, providing single occupancy or unisex restrooms can help reduce conflict and support students who need privacy, but this is one that really needs specific decisions.
Well, Scott, thank you so much. And I apologize to the registrants who sent us some of these questions we may not get to, but we can certainly provide answers in email and have a more thorough discussion. But I'm going to move a little bit forward to our last secret word of the day, and the answer is see heart. And I'll give everyone just a minute or so. And while we're doing that, I know there was a question about sort of the balancing of academic freedom. Maybe 30 seconds, Scott or Leah, I'll put you on the spot while we're allowing the attendees to answer C heart here. But anything about balancing academic freedom as it relates to some of the DEI policies?
You can grab that one.
I'll take a little bit here. Your academic freedom to teach and research, it all remains intact. You can teach the history, you can assign readings on gender theory, etc. You can facilitate discussions, but your legal risk is going to arise when identity-based criteria affect student treatment or access to opportunities. So requiring students to disclose their race or gender or sexual orientation as part of an assignment, offering extra credit to only certain students, those kinds of things are going to be where you venture into the legal risk territory. So again, that could be a whole topic or a whole presentation on its own, but there's a bird's eye view of it.
Great. Now I'm going to go back a bit. Stephanie, I believe you're going to at least address the first question here. Employee affinity groups organized around identity raise a distinct set of compliance questions. how are institutions approaching these groups within the current non-discrimination landscape, and what considerations should their structure and support, should guide their structure?
Yeah. Thanks, Trey. There are unique considerations here with affinity groups. Similar to the analysis that Christina discussed earlier, these are things too that have all been raised in the EEOC guidance that came out last year as well. And institutions, I think, believe and feel as though they need to support their employees. And in doing so, affinity groups can be one way to show that support, to say, here's a group of other individuals who may be experiencing similar types of issues or needing to address similar types of concerns. And historically, we've seen that as something that's been very supportive of employees on campus. Today, though, there are some concerns with having an affinity group that may exclude individuals of another protected category. So, generally, I think that there's been a movement towards still having affinity groups, still allowing for institutions of higher education to have, spaces where people can come and gather and discuss topics and issues that may be important to them, but ensuring that those groups are open to everybody, that it's not to the exclusion of another group, and then checking in and making sure that those things are still working within the needs and the support of the employees.
Great. Thank you, Stephanie. Now, Laurie, campuses are looking for clear guardrails as they adjust policies and practices. Could you offer concrete examples of actions that would be clearly unlawful, those that fall into a higher risk or a certain category, and those that are more likely to be compliant under current non-discrimination standards?
Yes, thanks, Trey. So the DOJ July 29th guidance again gives specific examples of what this administration views as unlawful. Again, it's not binding, but it does show us what their interpretation of the law is. And just going within the vacuum of scholarships, what's clearly unlawful is a race-based scholarship under this administration's interpretation of the Harvard decision. What's clearly not unlawful is if you offer scholarships that are, first-generation scholarships, socioeconomic need-based, that are not proxies for, a protected category, but in fact are offered for that reason. And particularly with those, institutions have been offering scholarships like that for years. So the history should help with any sort of argument that it's not a proxy. Falling in the middle of those is perhaps a scholarship that targets a particular geographic area. Depending on what the geographic area it is, it could be considered a proxy for, race or ethnic diversity. Whereas if you come up with a scholarship program, public institution says, I want to give a scholarship to one student from every county in the state, then that may look, obviously less targeted and more on the lawful side. Thanks.
Well, great, Laurie. Look, I think it's your point about the guidance from the administration. The administration has certainly shown its cards here, and any institution that may go outside of this runs the risk of being subjected to an investigation, litigation, a program review. And so again, you need to evaluate your own internal institutional risk tolerance and make it, your own determination about whether you want to change any of these, any of your programs or other policies. And we'll move along here. We have about 5 minutes left. This will probably be the last question that we get to. I believe it's for Brant. Compliance expectations are increasingly influencing how institutions work with outside vendors and service providers. How might evolving federal and state requirements shape the contractual terms, such as state-mandated agenda?
Thanks, Trey. In the current environment, I think institutions would be prudent to approach vendor selection decisions through largely the same lens as on-campus activities and employment. the administration has directed federal agencies to terminate grants and contracts with federal funding recipients that themselves make vendor contracting decisions based on the racial or gender makeup of the vendor, or that require vendors to meet diversity hiring metrics. When you contract with the federal government or receive grants, you certify that you will use federal funds in a way that complies with anti-discrimination laws. And so there really is there's a legitimate risk that if vendor contracting decisions are not race and gender neutral, your institution may be opening itself up to potential False Claims Act liability on the theory that compliance with discrimination laws is material to the federal government's payment decisions. Now, of course, there are perfectly legitimate reasons why institutions may elect to contract with a particular vendor, irrespective of DEI. Institutions can still engage in outreach to organizations that support minority-owned businesses to make sure their members are aware of opportunities for contracting with schools. But certainly your internal policies should not reflect or contain any language suggesting automatic preferences tied to protected characteristics. Now, as far as state-mandated addenda, that poses a difficult question. If state laws require diversity practices as a condition of state funding, but federal laws prohibit it, there's an obvious conflict there. That's a difficult situation, but you certainly may need to find a solution that segregates state-funded activities from federally funded activities so that you can comply with both federal and state laws. There was one question in the chat. The question was, can universities rent space to an external third party that limits their program based on a protected class? My colleagues may have other thoughts, but my reaction is that I do think universities can rent space to an external third party that itself limits the program based on a protected class. That third party may seek counsel, but so long as the institution itself is not making decisions based on that third party's own practices, it should not be subject to federal laws. But I would be curious if what my colleagues think about that.
Yeah, I think that's right, Brant. I just would make also clear the institution wouldn't be co-sponsoring, endorsing, promoting the event. It's clear that it's a third party, right? It's not part of the institution's own programs, and the institution's not providing differential treatment, right? They're not giving a break kind of based on the protected class. It's neutral, open to all. It's just the organization kind of comes in and there's that separation. Institutions also should have pretty robust liability indemnification provisions. Maybe something to consider if the group's a little riskier. Obviously, always look at state law and all those other kind of pieces too. But I think I'm same place as you.
Hey, Scott, if you don't mind, I think we got a question in the chat about GSA and multiple campuses. And I also had a request to go back to the first week of word. I'm going to do that in the slide. Will you just maybe talk about that question we received?
For sure. Let me find it.
Sorry to put you on the spot.
No, I let us follow up with this questioner because I don't think I have a good enough answer on the fly.
Yeah,
it's a good one.
I saw that question as well, and I think that would be one that we can follow up on.
We have a couple of colleagues, right, that specifically work in this higher ed grant space.
And obviously, I'm at the first week of words chocolate. We had a request to go back to this. I'm going to leave this here for about 5 more seconds, and then we're going to move along to the conclusion. I will say that obviously we appreciate everyone's time today. Please fill out the survey, give us feedback. We probably should have made this a bit of a longer webinar to say nothing that I'm sure it's felt a bit brush for the registrants and the participants, but we appreciate everyone's time. We also have a lot of materials available. You can scan this QR code through our blog, The Regucation, and we appreciate everyone. And I should have left this. We're going to stick around for another 5 or 10 minutes, try to answer the questions. I think Laura even had one more that we had preloaded. but I understand people have other obligations. So again, please feel free to grab any of our free resources. Look out for the higher education litigation email summary coming out tomorrow. Also, save the date. We'll be at NACUA this year. We're renting out a rooftop there on Broadway in Nashville from 12:30 to 4 on June 30th. Please come by and see us. And with that, we appreciate everyone's time. We're going to stay on if anybody else wants to, and we're going to try to get through the remainder of our questions. But thank you for your time today. And Lori, I'm going to go back to your question here about the ACTs and iPads. With the new ACTs reporting requirements and iPads, institutions are submitting more detailed admissions and enrollment data. Do you anticipate that federal or state enforcement agencies might use this expanded data set to identify potential DEI-related compliance risk? And how should campuses prepare for that possibility?
Thanks, Trey. Yes, I do anticipate and know that the administration is using this extra data to determine whether or not there's compliance with the Harvard decision. This data, institution-specific data, really only, even if it's skewed, it only provides evidence of a disparate impact, which this administration has eliminated disparate impact liability under its Title VI regulations. But it can also be one element of evidence of discriminatory intent. And it can't alone be all the evidence of discriminatory intent, but it can be enough for the department to launch an investigation searching for additional evidence of discriminatory intent. So as an initial approach, what can campuses do to prepare? Obviously, the first step is comply with the Harvard decision, and then train all of your admissions personnel on the what's prohibited under the Harvard decision. Also, institutions may use the data to do their own internal investigations and address issues before the government receives the data. And a lot of institutions have now hired a Title VI coordinator who would review the data and confirm whether or not there are issues with the Harvard decision compliance.
Great. Thank you, Lori. And with that, I'm looking through the questions. I don't believe we have any others other than the GSA proposed question that we're going to get back. And with that, I believe that's the conclusion. Again, if you're still there, please, wait, I've got one more here. All right. On the last question regarding universities hiring third parties that limit access, if the university provides campus security for the event and enforces restrictions that way, would it be exposed to risk? The institution could not offload responsibility on the third party. Is that correct?
Brant, what do you think on that one? Does the addition of the campus security and does that toe the or shift the scales in your opinion?
No, I don't think it does. I think it still would not be a federally funded activity. So I don't think in that situation that the university would be on the hook. I still think it would be on the third party. Just providing campus security, I don't think is enough.
Yeah, but I think the questioner's thinking about it the right way, right?
Yes, that's right.
Where's the line in terms of it's facilitating or endorsing or things like that? And
completely agree.
Yeah, and so campus, I think there you could make an argument, right? There could be some situations, but maybe this is on the safer side. But maybe something like putting up signage or something. Maybe that's the piece. So these are always fun but dangerous to answer in these kind of questions because there's so many things and so many considerations that we don't perfectly know.
Right, and I would also add, be careful if the vendor has some type of inside relationship with the institution, right? That maybe one of the trustee members owns the security company. I mean, again, just trying to give insight that could provide more problematic issues. But with that, I believe that concludes all the questions that we have so far. I appreciate everyone's attendance, and please fill out the survey. And thank you so much for your time, and have a great rest of the afternoon.
Thanks all.